Hello everyone, today we are going to discuss about international law, its definition and nature. Well, in simple terms, international law is nothing but a basic set of rules, agreements and treaties that are binding between the countries. Countries come together to make binding rules that they believe that will benefit the citizens. It is a complete independent system of laws existing outside the legal framework of a particular state. Various of the jurists have also defined international law. For example, according to Philip Jessup, international law or the law of nation must be defined as the law applicable to states in their mutual relation with states. Further, international law may also be applied to certain interrelationship of individuals themselves, which involves matter of international concern. It basically refers to the fact that international law is basically applicable within the two different states or many different states, and it also applies when it comes to relationship of the individuals who are citizens of different nation. And in fact, if there is any matter of concern that occurs on an international level. International law is a very complex and dynamic system of laws. It covers various wide range of topics such as trade, human rights, diplomacy, environmental preservation, war crimes, etc. It is different from the domestic laws in many number of ways. First of all, it is based on the consent of different states. Like the states have to agree to be bound by the international law. It can be done through treaties, customs, or the general principles of law. Second, the international law is enforced primarily through diplomacy and negotiation. There is no particular central authority to enforce the international law on states, and it is a constantly evolving field according to the changing needs of the international community. Let us have a look at the sources of international law. The Statute of the International Court of Justice, Article 38, outlines five major primary sources of international law, which are treaties between states, customary international law, general principles of law, judicial decisions, and the writing of legal scholars. One of the most debatable topics while studying the international law is that whether international law is a true law or not. Some of the jurists agree to the fact that international law is true law, but various jurists also contradict and have the opinion that international law is not law in true sense. John Austen, one of the leading English writer and jurist, support the view that international law is not law in true sense. According to him, international law is just a code of moral force and rules of conduct. He considers the fact that international law does not have any sanction behind it, and it does not comes from a definite authority. He considers international law as only one of the positive moralities and has the opinion that it is only followed by nation according to their own wish. Holland is another jurist which is of the view that international law is extremely different from ordinary laws as it is not supported by states' authority. He describes international law just as the vanishing point of jurisprudence and is of the view that international law lacks sanction, which is the most important element of municipal law. Thus, it cannot be regarded as a true law. Contrary to the opinion of Austen and Holland, there are other jurists who have considered international law as law in true sense. Oppenheim, Brierly, Hart have challenged Austen's perspective, arguing that it fails to account for the complexities of legal system, particularly in the cases where the customary or unwritten laws prevail. Oppenheim proposed a broader definition, asserting that the law is a body of rules of human conduct within a community, enforced by an external power with the consent of that community. This broader understanding of law finds support in recognition of international law by states and its application in resolving various disputes. Despite the absence of a centralized legislative authority, international law operates through a combination of customary practices, treaties, and conventions. Thus, we cannot disregard its value as law, and it can be regarded as law in true sense, according to Oppenheim, Riley, and Hart. One of the prominent jurists in the field of international law, Stark, is of the view that international law is a weak law because international legislative machinery mainly operates through conventions and it cannot be compared to the state legislative machinery. The various other reasons for regarding international law as weak law are that it lacks effective lawmaking authority. It also lacks effective machinery or authority to enforce its rules, and the sanctions behind the international law are really very weak as compared to the municipal laws. International law cannot intervene in the matters which are within the domestic jurisdiction of the states, and many rules of the international law are uncertain and vague. Despite being considered as a weak law, the importance of international law can't be disregarded. International law is undeniably important in influencing global affairs and supporting state stability and collaboration. International law is a set of rules which is necessary in order to regulate the behavior of nation states towards each other so as to ensure peace and welfare of the international community. It helps in resolving dispute amongst the states. International law may also influence internal laws too and may also become a part of domestic laws. As the globe is becoming more interconnected, the role of international law as a framework for addressing transnational concerns and promoting the common good is also growing.